Lawyer Rimbas Nalukola has traded judicial blows on the matters of constitutionalism and rights. Watching Friday's president's speech, he was not confined to the contents of the speech, but the narrative.
It should not be in a mere discussion and speeches. He knows the right procedure, but it is absurd that the President of the Republic of Uganda has such opinions that bail should be denied to suspects. He should know that bail is premised on the presumption of innocence. That somebody who is a suspect is presumed to be innocent until proved guilty by a court with a competent jurisdiction.
President coming out, to some of us, the human rights advocates, we think that it is a political statement or political discussion, which I think we should separate from it. At the same time, we should separate politics from the law. Why? Because an infringement of one's rights, an infringement of another person's right.
Emmanuel Dombo, the NRM Director of Information and Publicity, says President's speech should be viewed in the spirit of checking the responsibility of the judiciary.
We need either streamlining the law if the law is not clear, or clarifying by the head of the judiciary in exercising their discretion as judges or judicial officers. What are the considerations they might take in mind before they grant bail?
Now, to stop someone from applying for bail is an infringement of his or her right.
Nalukola says the president has missed able advisory.
Museveni should be advised to follow the right procedure. He should present a motion in the cabinet. They should come up with a bill with intentions of amending our laws if he wants to scrap off bail and bond.
He says Uganda, as a signatory to international conventions, demeans her image.
To be embarrassed in the entire world. You know, Chapter 4 of our Constitution was a kind of adoption of the entire Bill of Rights, the Universal Declaration of Human Rights. We are signatories to the International Covenant on Civil and Political Rights. All those instruments provide for bail, provide for bond.
We have seen, as the lawyers, especially who do criminal litigation, that only the application of the grant of bail changes someone. It brings back hope. Two, it is another way for a better preparation of someone's case.
He challenges the right procedures to be followed.
He knows the right procedure, but it is absurd that the President of the Republic of Uganda has such opinions that bail should be denied to suspects.
Dombo says judiciary's actions have created an uncomfortable situation for the public.
Exercising that discretion, many presiding judicial officers have released the people in a manner that has left a lot to be desired. When the community evaluates the decisions of the judiciary, they think it is the laxity of government that enables criminals, who we call suspects, to go back to the community and may increase incidents of mob justice.
One thing which I think the public has to understand, that bail is a constitutional right, or application of bail is a constitutional right.
However, Nalukola says stakeholders should counter such threats to national structures.
The world will condemn us. You know the universality principle of human rights? That when your rights are infringed, my rights are threatened. I have to be concerned when human rights in Democratic Republic of Congo are being infringed. The entire world will criticize us.
President Museveni's stance on a bail has scratched the core of the responsibility of the judiciary and the spirit of the Constitution. The fundamental question is the victim and the suspect, who takes the day. Simon Chris Makanga, CTV, PM Edition.